Welcome back to This Week in Immigration. I'm Jordan LaPier. On the program this week, green card suspensions take effect, but on a smaller scale than promised. President Trump suggests tying state and local relief funds to ending sanctuary city policies. And the Gavel. A look at the legal happenings on DACA, public charge, and more. All that's just ahead. Stick around. Here with me today, as always, are Theresa Cardinal Brown, Director of Immigration and Cross-Border Policy. She's on Twitter at BPC_T Brown. Hi, Theresa.
Hi, Jordan.
And Cris Ramón, Senior Immigration Policy Analyst on Twitter at CRamonBPC. Hi, Cris.
Hey, Jordan.
Thanks to you both for being here. First up today, on April 20th, President Trump tweeted that he would suspend all immigration into the United States to protect American workers and slow the spread of the coronavirus. But despite the sweeping nature of that statement, the final executive order he signed was more modest, suspending a certain set of green card categories, including nearly all employment-based visas, for 60 days. A Washington Post University of Maryland poll out this week found bipartisan support for Trump's measure, despite criticisms from immigration advocates and even some restrictionists. Cris, what are your reactions to the executive order and the president's reasoning in issuing it?
So I think in the near term, the way I interpreted this is obviously President Trump's approval ratings have dropped off significantly, since he kind of had a little bit of a rally around the flag effect in late March, and those disapproval numbers have increased since then. So I think what he was trying to do was, demonstrate a lot more control over the pandemic and the economic fallout from the pandemic to the public. Trying to show off that he was a decisive leader. Of course, what we do know is that a few days later, he made his comment about injecting certain kinds of chemicals into your body to take care of the virus, and that completely derailed, I think, the plan that he had and his administration had for trying to move forward with the messaging around immigration. So I think that, in the near term, he was trying to show off being a decisive leader, but unfortunately, he tripped up in his own words a few days later, and we aren't talking about this as much right now, but there's always open questions about the long-term view of this.
Yeah, I would say that, it first of all, consistent with his administration's rhetoric around immigration and the economic threat that migrants are. It's interesting that the actual proclamation, although it's based on similar grounds to the original travel ban that he issued at the beginning of his presidency, is very much about economic security. It doesn't actually lean on any way at all that this action would protect people from COVID or the spread of the virus, but it is entirely about the economic fallout from the virus and the idea that by barring certain immigrants from coming in, it would protect jobs for U.S. workers. But there's no evidence to that. It asserts that, but doesn't provide any evidence that these migrants would be taking jobs from American workers. So it's very broad and sweeping. It's an economic-based order, not a COVID-based order. And I think it is about taking advantage of the current situation we're in to advance essentially the same kind of policies around immigration that he had proposed 2 years ago during the DACA debate. That is to restrict most forms of extended family immigration, eliminate the diversity lottery program, and restrict some employment-based immigration. So I think well, there's probably a political motive and a public relations motive. Certainly the policy motive here is consistent with where his administration has been.
Cris, which kinds of green cards are suspended by this order? So who's affected and who's exempt?
So in terms of who is covered by the order, first and foremost, it's important to know that the employment-based visa category, there's 5 categories, EB 1 through 5. EB 1 through 4 categories are not exempt. They are covered by the ban. So individuals who are sponsored by employers who meet the requirements for those visas, they cannot come to the United States. So those are folks that are applying from overseas. They cannot come to the United States. In terms of family-based processing of green cards, In terms of who is not exempt, the adult children of American citizens are not exempt, and the immediate and extended families of green card holders, those individuals are also not exempt. So it's important to note that really folks who are applying from overseas, this is very important for a green card. A lot of those individuals are not exempt in the categories that I laid out.
It allows the spouses and minor children of U.S. citizens to come in, but it does not allow, for example, the parents of U.S. citizens to come in, nor, as Cris mentioned, adult children of U.S. citizens. I would also say, although the general categories of employment-based visas are barred, there are exemptions for people who are coming who are frontline healthcare workers, doctors, nurses, and other healthcare workers who are coming in to work, or people who are researching or are somehow necessary for the response to COVID. And those are on a case-by-case basis. So they may be sponsored in one of the other employment-based categories or as family members. It's not clear exactly how that will work, but if they meet one of those categories, they can also be exempted. There's some other small exemptions, people that the United States, for whatever reason, deems in the national interest. Those would be case-by-case determinations. And additionally, some special immigrant visas for those who helped U.S. forces in Iraq and Afghanistan are still eligible to come in. The other thing I would say is that, as Cris mentioned, it does not apply to anybody who's trying to adjust their status to get a green card while in the United States. And most employment-based green cards are given to people who are already in the United States. So this would disproportionately affect family-based migrants, more of whom are outside the country, than employment-based migrants, more of whom are inside the country.
And the other thing to know, obviously, is because it is a green card ban, it does not apply to temporary non-immigrant visa categories. Those folks are not covered by this at all. I think that was one of the things when this was reported, that there was a suggestion this might be the case. That is not the case. And I forgot to mention also the diversity visa lottery, that green card category is also covered by the order. So individuals who want to access a green card through that channel cannot do so for 60 days.
And as Cris mentioned, this is a 60-day order. It does not cancel the underlying petitions or approvals that these individuals may have had. So theoretically, if and when the order is lifted, they could resume processing and come in at that time. But there are provisions for this executive order to be reexamined at the end of the 60 days and possibly extended. And I think that's where a lot of the big concern comes in is what are the grounds under which it would be lifted or extended, and what is the likelihood that that would happen?
So, Theresa, I want to pick up on something you mentioned a couple minutes ago in terms of the folks who are seeking these green cards being here versus being overseas. How might that shape immigration to the United States in the short and in the longer term? Just the chance of who's affected by this order, what impact is that going to have?
So one thing to also understand is that this order was written at the time when most immigrant visa processing overseas was already shut down because U.S. consulates abroad had canceled most visa interviews, which are necessary to issue immigrant visas in light of COVID, except in emergency situations. So there was already essentially a pause on most immigrant visa issuance from overseas. So in the short term, it's not clear how much of an effect it would have. Should, however, this be extended for quite a long time, there could be significant impacts. One thing to understand is any employment-based visa depends on the viability of the underlying job offer. So if at the time this person is outside the country and goes in for their visa interview, for example, their company in the United States has rescinded the job offer or has decided that they no longer want that person, maybe due to the economic circumstances around COVID or any other reason, that underlying petition goes away, becomes invalid, and that green card is no longer available. So the longer this goes on, the more potential that could have. Also, family members, particularly minor children, can age out. So someone who's applying for an employment-based green card can also bring their spouse and minor children along with them. But if those children turn 21 while waiting for that green card, they're no longer eligible to come with the parent. And so again, delays of this type could mean that some people will no longer be eligible, depending on how long the suspension continues. In the longer run, it's worth noting that the allotment of green cards per year by each category is by fiscal year. So come October 1, or to be perfectly clear, by September 30th, if all of the available green cards are not used, then those unused numbers roll into different categories for the subsequent year. So, for example, as I mentioned, more family-based migrants are waiting visas outside. If they don't get to use those visas could be available for employment-based immigrants who are inside the United States either later this year or into next year. And if employment-based visas don't get used up again, then they roll back into family visas. This is very complicated math, the way the system is set up under the Immigration Act. So it could have those kind of implications. In the very long run, if this persists like the travel ban has for several years, it would significantly change migration to the United States in terms of particularly significant reductions in family-based migration from overseas to the United States and the elimination of the diversity category. So that's I think one reason why many people who follow this are quite concerned about the precedent this sets and the potential longevity of it.
Cris, I want to start with you on this one. What is your take on this Washington Post poll out this week that found bipartisan support for the president's measure? What does this say to you about the public's view of immigration right now?
So that polling was interesting because there was significant bipartisan support for a measure suspending immigration. There was even a support among individuals, I believe, 18 to 24, which I think a lot of folks assume that that's a generation that's a little bit more open to immigration, but there's even support there. And so what this shows that there does appear to be a consensus that this is something that the public does support. So that is one thing that we can see from that. But I do think that one of the questions I had after looking at the poll was, is this a policy, though, that people would want to be a priority for the administration or even for Congress? Is this the first thing that would come to their mind and saying, this is how the president can help me economically ensure that I have a job? And the problem is that when you have a yes or no answer in the way that poll was done, we just don't know that. We just don't know that context. And furthermore, we don't know from that yes or no question as to what types of immigrants, what channels the public thinks that we should suspend. It may be the case that they may say, sure, we see employment-based immigrants as potential individuals who will compete with us for jobs, but you know what, family members, that's fine, or vice versa. So I think that there's a lot of nuance and a lot of context that you just can't get about how the public actually sees this as a priority or the type of channels that should be suspended in light of this act. I think that probably is the most important thing. And until more polls are produced that look into that, I think we're just left with a lot of speculation of what that might be. So that was, I think, my immediate reaction looking at that poll.
Yeah, I would also just say that, it was framed initially as a temporary suspension, and maybe that's all it will be. And as a temporary measure in light of COVID, maybe that's more supported. But the longer it goes on, and the more impact it has on businesses in the United States who are sponsoring people or family members in the United States, particularly U.S. citizens who can't reunite with their family, that may change over time. So, one thing to look at, just do you support or not something in the abstract and immediate, but I think as we see over the long run, whether or not that's going to be supported. The other point I just want to mention again is there has been a lawsuit filed over this, just initially filed. We don't know how that's going to come out. But one of the biggest arguments in that lawsuit is that if you're asserting that you're protecting the United States workforce from immigrants, there are huge parts of the existing immigration law that say this is the process Congress has set up to do exactly that. And the president is saying by this executive order that those statutory requirements to protect the U.S. workforce in our immigration law are not sufficient. And I'm substituting my own judgment that we can't have this happen right now. That's very different from saying we're trying to protect our country from potential threats of terrorism or even potential threat from coronavirus. It's saying the president saying I need to take further steps to protect our economy than Congress has allowed. And Congress hasn't changed the law. They've looked at it. They've tried many, many times to change those provisions, and it hasn't done it. So that may be something that the courts look at slightly differently than previous times the president has tried to use this executive authority.
All right, after the break, tying federal relief funds to immigration cooperation. We're back. In recent days, President Trump floated via Twitter the idea that states and communities facing massive budget deficits due to coronavirus might need to change their sanctuary city policies before receiving federal assistance. The move marks another step in the administration's effort to go after sanctuary policies by withholding federal grants and taking local governments to court. Most courts have struck down these efforts over the last few years, though. So, Cris, can you explain what the president said in this tweet and how it fits within the administration's broader approach on the issue?
In the meeting, the president essentially floated the idea that states that needed financial assistance from the federal government that are in debt would need to basically comply with changes made to their sanctuary city laws if they have one on the books. The most prominent example, obviously, being California, which is SB 54. That's an example of a law that they would want to try to change. And these laws can vary, but the idea is just limiting cooperation with ICE. So how does this fit into the broader strategy? Well, the administration, has been doing two things on this front. The most relevant front is that the administration has, attempted to withhold federal funds from states and localities unless they complied with certain ideas around information sharing for immigration enforcement efforts. That's been one step that they've been doing. And then they've also used lawsuits, namely one against the state of California with SB 54 to sort of strike down those laws. So this very much fits in with sort of the approach that the administration has been using towards this. And it's been a longstanding priority for the administration since 2017 when they issued an executive order essentially on interior enforcement. One of the things being that they wanted to limit the existence of sanctuary cities in these policies. So it very much falls in line with what the administration has done.
The only thing I would add to that is that, the administration has tried primarily to withhold grants from the Justice Department, law enforcement supporting grants. And that's due to a series of court precedents that say that the extent to which the administration or any administration can withhold funds from a state or locality or jurisdiction in order to try to encourage a certain type of behavior have to be somewhat limited, or it runs afoul of constitutional separations between the federal and the states. So, for example, having the money to be withheld be related to the object of the policy is relevant. So one of the questions would be how withholding widespread coronavirus relief money is related to the objective of law enforcement cooperation. That may be deemed by a court to be too broad. And in these lawsuits, even though they have been mostly about the Justice Department funding, so far, the administration has not succeeded in winning those lawsuits. Some of them are under appeal, but initial court decisions have said that the government cannot apply more criteria to these grants than Congress set out when they enacted the grants. Now, so far, Congress hasn't enacted any monetary assistance to states and localities as part of COVID relief. That's under discussion for the next bill. So the president seems to be laying down a negotiating marker here. But whether or not that marker, one, would be sufficient to, get his way in a broad negotiation over a broad coronavirus relief bill is one thing. Whether or not such a requirement would then be held up in court at a later time is another. But as Cris mentioned, this administration has been consistently opposing sanctuary policies by various jurisdictions and done as much as it possibly can to try to get those jurisdictions to change their policies. And this is another effort at leveraging, what states and localities are asking for to that end.
So, Theresa, let me just pick up on that. Can can the administration, let's say that Congress does appropriate relief funds for state and local governments, can the administration take steps to unilaterally withhold those funds if they are congressionally appropriated?
If Congress doesn't put that requirement as part of the funding and the administration tries to add it on its own, I think that would be highly legally suspect. And that's essentially what courts have said so far, is that, for example, the Justice Byrne grants, which are state and local law enforcement grants and community policing grants, there is no legal provision saying that the administration can withhold funding based on immigration cooperation. And so courts have ruled that that is not a ground under which they can withhold the grants. So I think it would be a difficult thing for the administration to try to do, to withhold the money if Congress doesn't explicitly say that's a condition of the grants.
Sticking with you, Theresa, what's the larger history here? The Trump administration, of course, is not the first one bedeviled by the patchwork of state and local laws on federal immigration cooperation. But why is this administration so focused on this?
Well, I think some of it is just President Trump has run on a hardline immigration enforcement platform. It is true that most of the sanctuary jurisdictions we're talking about are places that maybe did not support him in the election. So there's an electoral issue here. It certainly is an issue that resonates with his base. But also, I think that his is the first administration to really try and, if you will, put the screws to sanctuary jurisdictions at the same time as he is ramping up enforcement, making those policies more relevant for the jurisdictions that have them. I think under, at least the last half of the Obama administration, when interior enforcement numbers were down, the policies existed, but were not tested as strongly as they are now. President Trump highlighted this issue even during his campaign in 2016 with the murder of Kate Steinle in San Francisco by an unauthorized immigrant. Who was later acquitted of the crime, but he made that a cause célèbre, and the fact that sanctuary jurisdiction in San Francisco did not allow that individual to be turned over to ICE became part and parcel of his election platform and just carried over into his administration. And of course, his first Attorney General, Jeff Sessions, who had railed against these policies as a senator, led the charge in terms of pushing the allocation of these grants based on these jurisdictions, and in taking the lead and suing these jurisdictions over these policies as well. So it is definitely part of this administration's goal to see what they can do to make this as hard as possible for those jurisdictions that have these policies in place.
Yeah, the only thing I would add there is with the focus of what's been happening at the U.S.-Mexico border, I think the emphasis on these jurisdictions in terms of what the administration's been wanting to do with these policies hasn't been nearly as strong. But I think this is now that the border, in their view, has been sort of controlled, they are starting to look inward towards other issues, namely interior enforcement like this, or even like what we were talking about in the last segment, restricting legal immigration. So it was a real area of focus in 2017 and 2018, and then things changed at the border. But now that the apprehension numbers have dropped off, I think that the administration is going to be focusing on these two issues moving forward.
Okay, when we come back, the gavel. Finally today, it's the gavel. Our rapid-fire look at the legal happenings surrounding immigration in federal court. This time, we're focused on a rash of coronavirus-related legal cases. First up, last month, a U.S. citizen married to a non-citizen sued the Trump administration for denying them stimulus checks provided by the CARES Act, which denied payments to these types of marriages. We've covered the stimulus payments and immigrants in recent episodes, but Theresa, can you give a quick summary of the issue?
Sure. So the stimulus payments under the CARES Act granted up to $1,200 to married couples who make below a income threshold, plus another $500 per child, as basically stimulus money. It's styled as a advanced tax refund, if you will. That's not taxable, but it was basically a check given to every household. But one of the conditions included in the statute was that in order to qualify, you had to have a Social Security number. Now, as we've talked about on this podcast before, many unauthorized immigrants pay taxes and file tax returns using something called a individual tax ID number, an ITIN, which is not a Social Security number, but is a number that allows them to file and say, I have paid taxes, and or get tax refunds if they are available to them. For many of the undocumented immigrants to do this, this is a way of saying to the United States, I'm trying to be law-abiding, I am paying my taxes. At some point, should you decide to legalize me, I want to show I'm going to be a good citizen. But the truth is that millions and millions of dollars are paid into the Treasury every year by undocumented immigrants who pay taxes this way. And there are millions of families that are mixed status. So U.S. citizens who have a Social Security number will file a tax return with a spouse who may not have a Social Security number. And that is the type of family that is covered under this lawsuit. U.S. citizens are alleging that they are being discriminated against in the allocation of these visas unlawfully because they have chosen to marry someone who does not have a Social Security number.
All right, so what did the plaintiff argue in this case?
So the plaintiff's lawyers are trying to make this a class action, and they are arguing that this discrimination under the law violates two parts of the Constitution. First is the Fifth Amendment to due process, that they did not have a process to try to appeal this or any other way of asserting their rights under this. And secondly, that it violates their freedom of association under the First Amendment. That is the same argument that was made in the Supreme Court case over gay marriage, which said that U.S. citizens have the right to marry who they choose to. And in this case, they're saying that by this discrimination, the government is unlawfully discriminating against them based on who they chose to marry, and that is a violation of their freedom of association in the First Amendment.
Cris, what are the implications of this case?
If it were to move forward, you'd have a pretty significantly large class action lawsuit. I think 1.2 million U.S. citizens are married to non-citizens of varying statuses. So if you were able to move this forward, that would be a pretty significant number of individuals making these claims, and then that if they were to be successful, that would result in a pretty large payout and additional costs to the federal government if the plaintiff succeeded. Obviously, the other thing to consider, if this were to be successful, more people obviously would have more stimulus checks, and there might be a little bit more financial stability for these families. But I think right now it's just very preliminary. We just don't know where the lawsuit's going to go and whether or not the plaintiff might be able to prevail on the point that Theresa raised. So just wait and see, as we've always been doing with this segment.
One thing to keep in mind is that Congress may consider another stimulus effort down the line, and certainly many Democrats have raised this issue since the passage of the first CARES Act, and may try to issue a correction or a fix for this in subsequent legislation. So it's a legal issue right now. It may also be a legislative issue down the line.
Next up, the Supreme Court agreed to review a new brief submitted by immigrant advocacy groups in the case surrounding President Trump's decision to terminate the DACA program. Theresa, what did that brief say?
So this brief was submitted by a bunch of plaintiffs and in the DACA case, and to basically ask the court to consider the potential impact of COVID on this DACA case. It notes that approximately 27,000 DACA recipients are currently employed in frontline healthcare positions on the lines fighting against COVID right now, and that a decision that went adverse to their status would not only take them out of the workforce, but would destabilize the response in many jurisdictions around the country. And this is the type of extenuating circumstance, if you will, that happened after the court had heard oral arguments on this case. If you remember that the Supreme Court heard oral arguments on the DACA case last November, it was widely expected, and it is still widely expected, that the Supreme Court will rule on the case this term. And that could be any time now, actually. And basically, the plaintiffs are saying, either please hold off on issuing your decision or reconsider whatever decision you might make in light of the impact we're having with COVID right now.
Theresa, how unusual is this decision by the court to review this new brief so late in the process? As you said, we've thought that a ruling could be coming the last few weeks. We've thought any time now.
Yeah, so it is highly unusual. First of all, you can't just randomly submit a brief to the court. You have to get the court to agree to accept a brief. And the plaintiffs in this case made this argument. And unusually, the court did say, yes, we will accept this brief. It will become part of the record of decision on this case. Usually, it only happens, as I said, when there is a significant change of circumstances following the oral arguments. And I think the plaintiffs in this case successfully argued that the impact of coronavirus was a significant event that could have effect on the way the court would look at the decision in this case.
How do both of you think this step by the court scrambles thinking around the potential outcome of this case?
It's really, like Theresa said, this is such an unusual step that at least for me, the key question is how far along is the court with its decision on with DACA and the extent to which the court assesses whether or not this is really a decision that needs to be made right now. But of course, the court is a black box. You don't know what they're actually thinking. They're not going to come out and make a public statement. So I think at this point, there's just a whole lot of speculation about what potentially could happen.
Yeah, and again, the order accepting the brief was unsigned, and it did not indicate whether there was any dissent in the decision to accept the brief. It just said that the court accepted it. And as Cris said, what we don't know is whether they've already had a conference on it among the judges, whether they have settled on their position and are in the process of writing the decisions now, and would that have to be changed or amended, or whether they still haven't yet necessarily decided the case. So we don't really know how this will affect it. I think many court observers believe strongly, given past recent rulings by this particular case, that a decision might very well go against DACA recipients in favor of the Trump administration. And I think that's another reason why the plaintiffs really wanted to file this brief, is because there is huge concern about the disruption caused not just to DACA recipients and their families, but to their employers, their communities, and many other people who filed this case in the first place, if they were to lose status very rapidly based on the Supreme Court case. There's a lot of effort to try to get Congress to relook at this. Obviously, Congress can fix this at any time it chose by passing legislation regarding the DACA recipients, and there's been attempts to do so. And there will be a lot of pressure, I think, when the Supreme Court rules for Congress to take up this issue, particularly if Congress rules against the DACA recipients and in favor of the Trump administration.
All right, lastly, in the Gavel, the Supreme Court also denied a request from immigration advocates to stop the public charge rule from going into effect over coronavirus concerns, but the court did leave open the possibility for the case to head back to a federal district court. Theresa, what happened with this decision?
Yeah, so this was another kind of unusual one. The court a month or so ago, earlier this year, put a stay on lower court injunctions against the public charge rule. So lower courts had basically issued a nationwide injunction preventing the administration from implementing the public charge rule. The administration went to the Supreme Court to appeal those injunctions, and the Supreme Court granted the Trump's administration motion to stay those injunctions. So the rule is in effect right now and will be while the cases are making their way through the lower court. Just like in the DACA case, a group of plaintiffs went back to the Supreme Court and asked them to lift that stay, to allow the injunctions to be put in place and put the public charge rule on hold in light of the coronavirus. Their fear was that it was unfairly or it was inhibiting many immigrants and their families from seeking care in light of coronavirus, and that could have public health implications. The government opposed the motion, saying we've been very clear that any access to testing or treatment for COVID would not be considered against someone under the public charge rule, and therefore this stay is not needed. The court ruled with the administration. So at this point in time, the public charge remains in effect. But the court's decision, it was a very short order, said explicitly that the plaintiffs could, if they chose to do so, go back to the lower courts again and argue this before them. And so a group of attorneys general led by the New York Attorney General have decided that's what they're going to do. So this isn't over. but like many other cases that we've covered in the Gavel, is bouncing between lower courts and the Supreme Court and back to the lower courts again.
So what options do immigration advocates have in this case now?
Well, as I said, they are the attorneys general and advocates will be supporting lower court briefs to try to get lower courts to put a new injunction in place that would then probably also be appealed to the Supreme Court. In terms of immediate advocacy, again, the public charge rule is in place, and really the only relief could come either from the courts if the administration were to change its mind and issue a broad-based stay of the ruling. That does not seem likely given how they've argued in court, or if Congress were to step in at this point in time. And all of those are, I think, possibilities, but not likely at the moment. And so I think I would say to immigrants who are concerned about this, the government has said very explicitly and stated to the Supreme Court that they will not hold against any immigrant any medical treatment they seek for COVID or testing for COVID during this emergency. And they should take them at their word on that and not hesitate to seek treatment or testing if they are concerned for their health.
All right, that's a good place to leave it for today. Theresa, Cris, thanks for joining me as always. And thanks to you all for listening. We will be back in 2 weeks. But before we go, a quick reminder to subscribe, rate, and review this podcast on Apple Podcasts, Google Play, Stitcher, Spotify, or your favorite podcast platform. You can also find more information on all the issues we discuss here on the show at bipartisanpolicy.org/immigration. This Week in Immigration was created by Theresa Cardinal Brown and myself. The executive producer of This Week in Immigration is Theresa Cardinal Brown. This week's episode was written by Cris Ramón and myself. Our producers are Cris Ramón and Yafat Tawahada, and our editor is Yafat Tawahada. And the executive producer of BPC Podcasts is Ashley Swearingen. I'm Jordan LaPier. Join us again next time on This Week in Immigration.